Afternoon. For my talk today, I would first present the biblical basis for the position that I'm presenting, which is in the beginning it wasn't so. Then after that, I would give a brief distinction between the declaration of nullity and divorce. Thereafter, I would be sharing a portion of my research paper that I submitted for one of my LLM classes from University, Graduate School of Law, on that topic. So without further ado, let me just share my screen. Okay. All right. In Mark chapter 10, verse 1, Jesus himself was asked that very question. And let me read. And he left there and went to the region of Judea and beyond the Jordan, and crowds gathered to him again. And again, as was his custom, he taught them. And Pharisees came up, and in order to test him, asked, "Is it lawful for a man to divorce his wife?" He answered them, "What did Moses command you?" They said, "Moses allowed a man to write a certificate of divorce and to send her away." And Jesus said to them, "Because of your hardness of heart, he wrote you this commandment. But from the beginning of creation, God made them male and female. Therefore, a man shall leave his father and mother and hold fast to his wife, and the two shall become one flesh. So they are no longer two, but one flesh. What therefore God has joined together, let not man separate." And in the house, the disciples asked him again about this matter. And he said to them, "Whoever divorces his wife and marries another commits adultery against her. And if she divorces her husband and marries another, she commits adultery." Okay. So let me now give you a background of this pericope. If we would notice, the people who asked Jesus about or whether is it lawful for a man to divorce his wife were Pharisees. And we have to remember that the Pharisees were Jesus's number one opponents. And they always sought an opportunity to trap him. In a lot of instances, their questions aimed at trapping him or entrapping Jesus into giving an answer that would make him look bad either from the point of view of the Roman authorities or from the point of view of the Sanhedrin, which is the Jewish council of his time. If I may give another example regarding that, when he was a time when he was asked about whether it was right or correct to pay taxes to Caesar, and we all know his answer to that, wherein he got a coin and asked the Pharisees, those who asked him, whose image was there on the coin, and of course they said it was Caesar's image. And we now know that his famous reply to that: "Give to Caesar what is due to Caesar, and give to God what is due to God." In that instance, Jesus knew that if he said that we should not pay taxes to Caesar, then he would be guilty of sedition or rebellion, or of course tax evasion. Basically, he would be violating the Roman law. And if he says that it is okay to pay taxes to Caesar, then he would be branded as a traitor to the Jews, which he was a part of. Because as we know, the Jewish nation Israel or Judea during that time was under the Roman rule. Okay, so in this instance, in Mark chapter 10, it is the same. It is the same situation. Jesus was being asked a trap question or a trick question, as we know. During that time, even the Pharisees were divided into two factions or two groups. There are those Pharisees who were of the position that divorce is only allowable in cases of marital infidelity or sexual perversion or sexual immorality. In Greek, the word used was porneia. So it could be sexual infidelity or adultery or any form of sexual immorality. On the other hand, there's this group of Pharisees who believe that a person may divorce his wife for whatever reason, just as what our previous speaker mentioned, wherein is it in India, right? If I remember it right, the man divorced his wife for feeding him instant noodles or ramen every single day. So it could be any reason, okay? So there are two factions. So if Jesus answers one way, he would be uh, in trouble with the one group, and if he answers the other way, he would be in trouble with the other group. So again, it is a trick question. So how did Jesus address the question? Is it lawful for a man to divorce his wife? So Jesus answered the question by throwing back at them another question. So what did Moses command you? So in the law, take note that in the Pentateuch, or in the first 5 books of the Bible, also known as the Torah, Moses was the one who handed on God's laws to the people of Israel. And the Pharisees answered correctly that Moses allowed a man to write a certificate of divorce and send her away. Now, why was that allowed during the time of Moses? Jesus gave the answer, it's only because of the hardness of their hearts. In Filipino, matigas ang ulo ninyo. Okay? Then Jesus proceeded to go back from the very beginning and showed and told everyone the true meaning and true purpose and intent of marriage. From the beginning, God made them male and female. And when a man leaves his father and his mother and holds fast to his wife, the two shall become one flesh. When something becomes of one flesh, then they cannot be separated anymore. And he even said, what God joined together, let not man separate. So the point here is, Jesus answered the question by going back to the very beginning, from the time in Genesis where God instituted marriage. That God's original plan for marriage was for it to be indissoluble, for it to be a permanent union between a man and a woman, a husband and his wife. And Jesus even further qualified his statements when they got home, in wherein he said that a person who who divorces his wife or even her husband and marries another commits adultery. And here's the thing: this pericope in Mark makes us go or leads us to another portion of the Bible wherein divorce was or marriage was discussed, this time by the Apostle Paul. And basically, in this instance that I will be showing you, the Apostle Paul continued on what Jesus taught. In Ephesians chapter 5, verse 31, or in fact, beginning verse 22, Paul talked about wives and husbands, or basically marriage. And he gave uh, he told the disciples how a marriage should be, how a husband and a wife should behave to his or her spouse. In verse 31, he said there, therefore a man shall leave his father and mother and hold fast to his wife, and the two shall become one flesh. We should recall that when Jesus quoted this specific or this particular verse, and in same thing with Paul, this was actually a quote from the Old Testament in Genesis chapter 2. Therefore, a man shall leave his father and his mother and hold fast to his wife, and they shall become one flesh. So again, this was the original intent of God when it comes to the institution of marriage. But here's the clincher. In verse 32, the Apostle Paul says, this mystery is profound, and I am saying that it refers to Christ and church. Okay, so what does that mean? Here, the Apostle Paul is comparing the institution of marriage to the relationship between Christ and his church. For those of us who know theology and who know the Bible, we know that the church is the bride of Christ. And being the bride of Christ, the church is in the second coming, the church is to marry Jesus Christ. Christ is the head. Christ is also the groom of his church. And now the Apostle Paul is comparing the relationship between a man and a woman to Christ's relationship to the church. Okay, so what's the significance of that? The significance is that When Christ marries the church or his church, then there is no more separation. What God has joined together, no man shall put asunder. It is a permanent union. Otherwise, we would have no assurance of salvation, no assurance of safety, no assurance of heaven, and no assurance of God's companionship. And that is the clincher there. That's why in the beginning, if we go back to the beginning, to the original purpose and intent of marriage, we can see from the Bible, from Scripture itself, from the Word of God, that God really intended marriage to be a permanent union in a man and a woman. Although later on, divorce was legalized, but only because of their hardness of heart. Why was it necessary? Because during that time, what would happen was, even though the men were married, they would just get a concubine, they would get another woman and leave their wives and establish a new family with another woman. And that would leave the wife in a precarious position. Remember, in that she would be left alone with no one to support her, with no husband to support her financially and materially. And if she goes to another man for support and establish a relationship with another man, then she would be stoned to death, because that was the law of Moses during that time. That was the law during that time. So in order to prevent that, Moses allowed divorce, but in reality, from the beginning, God never really intended marriage to be soluble. So God intended marriage rather to be indissoluble. Okay, now let me proceed with the differences between divorce, absolute divorce, and the declaration of nullity or annulment as we have it in the family code. Why is it that, let me just remove this. Why is it that the church usually allows or consents to having laws on declaration of nullity or annulment, but not divorce, but not absolute divorce? A lot of people that I have been reading in the comment section on social media will say it's all the same. The marriage is still dissolved. Why is the church against divorce but not against declaration of nullity or annulment? So before I go there, currently under the family code, we have two modes of dissolving marriages. And this is a huge source of confusion for most people. Most people, you would hear them say that or talk about annulment. Annulment this, annulment that. Oh, annul ka na. But in reality, what they are referring to usually is Article 36 of the Family Code, which refers to psychological incapacity. The ground of psychological incapacity is not a ground for annulment, but instead a ground for the declaration of nullity of marriage. Under the Family Code, there are different sets of grounds. A declaration of nullity presumes that there was no marriage at all, that the marriage was void from the beginning. On the other hand, an annulment presumes that a marriage is valid until annulled. As an example, let's say there was a shotgun wedding, there was force, threat, or intimidation. It's possible that the consent of the person getting married was vitiated or was not perfect because he was just threatened to marrying this woman. However, during the course of their marriage, he really fell in love with her and really decided to stay with her. Then all this means that although the marriage in the beginning was voidable or could have been annulled, he decided to continue it and ratify that marriage. So it is still valid. They don't need to get married again. However, in the case of declarations of nullity, these pertain to void marriages, void from the very beginning. That means that there was no marriage at all because of certain grounds that we can find in the family code. However, in absolute divorce, the difference is that we are presupposing a valid and subsisting marriage. Okay, that is the difference. That is why we are against divorce. By the way, I am here representing the view of the evangelical view. And incidentally, last Sunday, last week, this week, last Sunday, it was the sermon, the topic of the sermon in CCF. I'm not from CCF, I'm a Southern Baptist pastor, but I just so happened to attend CCF last week. And that was the topic, divorce and abortion. So the reason why we are against divorce is that it presupposes a valid and subsisting marriage that we are cutting off. Unlike in declarations of nullity, wherein the marriage is void ab initio, there is no marriage at all. All we are asking for is a declaration from the courts that the marriage is indeed void or was indeed void from the very beginning. And in the cases of annulment, there were circumstances that have vitiated or made the consent imperfect. That's why the marriage was voidable. Okay, and so they have different sets of rules. So take note of that. That is the difference between annulment, declaration of nullity, and on one hand, and divorce on the other hand. If a marriage is valid and is truly subsisting, then as the Bible says, as I quoted earlier, what God has joined together, let no man separate. Marriage is from the beginning indissoluble. Now, I would like to proceed to some suggestions, and I would give first a background information, no? Or some alternative solutions to this. The previous speaker mentioned the family code, and yes, the family code does indeed contain or include provisions that would address certain problems and therefore declare a marriage void from the beginning or voidable or annul it. So let me now share screen again. Let me share with you a certain portion of my paper. So marriage is a foundational institution of society, is governed by legal frameworks that shape its understanding, regulation, and consequences in the Philippines. So the legal framework for marriage primarily resides in its family code. However, a compelling argument can be made for incorporating more aspects of canon law as promulgated by the Roman Catholic Church into the civil law governing marriage. So this paper that I submitted explores the rationale for such integration and its potential benefits for Philippine society. Oh yeah, and I just realized my dean is right here. Our dean of the Sunbed, the Graduate School of Law, is right here with us. It will be the next speaker. So anyway, so when Philippine law recognizes marriage as both a contract and an institution, Christian theology and canon law, in addition, further characterizes marriage as a covenant. So that is one difference. Again, another difference. While civil law only recognizes marriage as a special contract provided in the family law, in the family code rather, in Christian theology, marriage is more than just a contract. It is a covenant. So in contrast to a mere contract, a covenant is an ancient construct wherein two parties promise to do something or not do something. Because of the fallen nature of humanity, the covenant may include penalties for breaking the covenant, but unlike a contract, it is considered immoral to break a covenant. It is a betrayal of trust. There is never a sense in which it is morally upright for a person to break a covenant, even if the covenant breaker is willing to pay the penalties. In short, by nature, marriage is a covenant between a man and a woman, setting up a partnership involving their whole lives, to the point that they become two lives in one. Aimed of its nature towards a double end, which is the full personal development of the spouses and the procreation and education of the children who may result, it is in function of this twofold end that the essential properties of marriage follow, which is unity, monogamy, and indissolubility. That's why in our marriage vows, we mentioned that till death do us part, right? So till death of one of the spouses. Nevertheless, in both Philippine civil law and Roman Catholic canon law, only a man and a woman of sufficient age and understanding can enter into it. Because remember, one of the elements of marriage is consent. So canon law, rooted in the teachings of the Catholic Church, provides a comprehensive and nuanced perspective on marriage. It emphasizes the sacramental nature of marriage, defining it as a covenant between a man and a woman that is both a natural institution and a divine ordinance. Canon law articulates principles of consent, capacity, and the essential properties of marriage, which is unity, fidelity, and indissolubility, that are integral to the Catholic understanding of this union. Now, why am I, a Baptist pastor, talking about Catholic canon law? Well, there's nothing wrong with that. Later on, we will find out that the family code itself copied certain portions from the canon law. Okay, you will see that later. So while the Philippines is a secular state, the Catholic Church plays a significant role in shaping the moral and cultural landscape. Canon law, with its emphasis on the sanctity and permanence of marriage, can complement civil law by providing deeper ethical and spiritual foundation to the legal aspects of marriage. A while ago, again, the family code was mentioned. However, admittedly, there is a dire lack of circumstances or grounds in the family code, particularly in the declaration of nullity and also in the annulment grounds, that are insufficient. Yes, they are there, but really there are a lot more instances that we can actually find stated or cited in the divorce bill. But my point is this, even this is actually the point of this paper. There is really no need for a divorce law. Why? All we need to do is to improve and enhance our existing laws on declaration of nullity and annulment in the family code. And we can do that by, number one, number one, incorporating more of canon law provisions into the family code, or number two, recognizing declarations of nullities granted by the ecclesiastical tribunal of the Catholic Church. That was actually a subject of a dissertation by Bishop Noli Bucco, and in which he wrote a book, Freeing Distressed Couples from Guilt, and the need for state recognition of the Church's declaration of marriage nullity. So if you can see, if you look at, wait, let me stop sharing first. So this is the book, no? Oh, you cannot see it because of my, but yeah, but you can check it out, Bishop Noli Bucco's book. So let me share screen again. So while the Philippines is a secular state, the Catholic, I've already mentioned this, no? So nowadays, however, there have been vehement clamors from different sectors to amend the family code of the Philippines, particularly to legalize same-sex marriage and divorce, among other things. Okay, now, point here is Article 36 of the Family Code, which is the ground of psychological incapacity, was actually taken from the Code of Canon Law. Okay, here, let me read this portion. In an effort to avoid legalizing divorce and incurring the ire of the Church, the drafters of the Family Code copied, albeit not verbatim, Canon 1095, paragraph 3 of the Code of Canon Law. So the copied version has become popularly used and abused Article 36 of the Family Code, which again, psychological incapacity. So let's look at them. Let's look at them side by side. So from the Code of Canon Law, it's provided there that the following are incapable of contracting marriage. Paragraph 3, those who are not capable of assuming the essential obligations of matrimony due to causes of a psychic nature. So a marriage contracted, here, let me look at that. So that's from the Code of Canon Law. From the Family Code, a marriage contracted by any party who at the time of the celebration was psychologically incapacitated to comply with the essential marital obligations of marriage shall likewise be void, even if such incapacity becomes manifest only after its solemnization. So we can see here that there was a slight change. Although they adopted it from the Code of Canon Law, they changed the wording and in effect also limited the definition or the scope of the ground, the said ground. Okay, so even the Supreme Court elucidated the canon law origins of Article 36. Even also, interestingly, here's the thing, one of the drafters of the family code, the late retired Court of Appeals Justice, was one of my professors in Lyceum. During one of our classes, she mentioned in passing that there were instances wherein the Supreme Court would interpret the provision of the family code in a way that is different from the original intent of its drafters, particularly in the case of Republic versus Orbecido. So this dealt with the case of a divorce secured or divorce decree granted abroad. Okay. So in my, she cited, Justice MPD cited the following reasons for the Family Code Committee's adoption of the above quoted provision of the CIC as a ground for declaration of marriage nullity. So here were the grounds that she cited. So as a substitute for divorce, because divorce is very controversial, and it would be strongly opposed by the Catholic, not in conflict with traditional civil law, concept of voidable marriages. Number two, as a solution to the problem of church annulled marriages. So there are many marriages that have already been annulled or declared nullified by the Catholic Church, but still exist under civil law. Because take note, even though a person or a Catholic has already secured a decree of nullity from the ecclesiastical tribunal of the, this still is will not be recognized by the civil courts, by civil law. Hence the proposal of Bishop Noli Bucco to recognize decrees of nullity granted by ecclesiastical tribunals of the Catholic Church. So this provision would give many parties to church annulled marriages a cause to have their marriage declared void by the civil courts. Third, as an additional remedy, the provision would give a remedy to parties who are imprisoned in a marriage that exists in name only, as they have long separated because of the inability of one of them to perform the essential obligations of marriage. Now, I cannot go through all of these grounds, but my point here is, and if you can actually read this paper of mine, there are still many further grounds in the Code of Canon Law that can be and should be incorporated, either incorporated into the family code, or just the state should just draft a law, a bill, and pass a law recognizing the declarations of nullities given by the Roman Catholic ecclesiastical tribunals. So those are the two things that can be alternatives to the legalization or the passing of an absolute divorce bill. There is really no need for an absolute divorce bill, but we can instead improve our existing laws on declarations of nullity and annulment. I don't think I need to repeat all the other grounds mentioned by the previous speaker. And even the second to the previous one, the one from the IFI, the concerns are valid. All the concerns regarding abusive spouses, not only husbands, but as mentioned, even wives, they're all valid. We are not discounting the validity of all those concerns, all those complaints. But what we are saying is, we cannot correct a wrong by another wrong. There are better alternatives. There is a better alternative to legalizing absolute divorce. And it's already there. It has been existing for hundreds of years. All we need to do is to study it and adopt it. In my paper, I have given certain examples of other provisions that we can adopt. Okay, because really, admittedly, as I even mentioned here, the family code provisions on dissolution of marriages is really insufficient, and we need to add to it. Okay, so I mentioned here in my paper, I mentioned the other grounds available in the Code of Canon Law that we can adopt. So if you want to know more, yeah, feel free to contact me, message me through Facebook. But with the time that we have today, that's the best that I can give. I can only give us an overview and a general idea of an alternative to legalizing absolute divorce. Now, if you want a copy of my paper, just send me a message and perhaps I can share it with you. Thank you very much and God bless.